Dumelang! Welcome to my channel, Botswana Thinking Law, where I bring you and the law closer. Today in this video, we're starting a series on trusts. But before we get started in this video, I'd like to put in a disclaimer. This is not legal advice. This is simply a sharing of general information. If you have a problem of a legal nature, please engage the services of an attorney. Now back to our video. This video series is going to be divided into 3 parts. And these parts are going to be dealing with, in this first part, trusts generally. Part 2 is going to be dealing with what should be inside a trust instrument. And part 3 will be dealing with the rights and responsibilities of trustees. Now, this is all based on the Trust Property Control Act number 4 of 2022, which is currently in effect. Now, the first question that people might ask is, what is a trust? A trust is an arrangement where one person puts their property in the hands of another person for that person to use for the benefit of someone else. This person who has the property and gives it away is the founder or settler of the trust, and then the person who receives this property on behalf of another is the trustee. And then the person who the trustee holds the property for is the beneficiary. So a trust has to have a founder or a settler, it has to have a trustee, and it has to have beneficiaries. And one important thing is that there has to be a giving of property, and this is a donation. This property can be in the form of money, it can be in the form of a car. Any form that a property can take can be donated for the creation of a trust. A trust is created in this manner in writing. So there has to be a document that shows who the founder or settler is, who the trustee or trustees are, and who the beneficiaries are. It should also indicate the property that is being donated. And this document that sets all of this out is what is called the trust instrument. First, let's talk about the founder. The founder of a trust can be a natural person, being a person of flesh and blood, or it can be a juristic person. And by that we mean a person who is created through the law, like a company. And then a trustee can be a natural person or a juristic person. But if the trustee is a juristic person, it has to appoint a natural person to act for and on its behalf. And then finally, with the beneficiaries can also be juristic or natural persons. For example, a beneficiary can be a homeless shelter. So maybe if someone wants to create a trust for the benefit of SOS, for example, a beneficiary can also be a natural person, so a person of flesh and blood. For example, if I as Bonolo want to create a trust for the benefit of my grandchildren, then I would be the founder. But there is nothing in law that also stops me from being a trustee with other people of that trust. And the reason why I cannot be a trustee by myself is so that it is clear that I'm creating the trust for the benefit of the beneficiaries, not simply to try and hide my assets. So if I create a trust, I can be a founder, I can be one of the trustees, and I can be one of the beneficiaries. But I cannot be all of them by myself. That is not the creation of a trust. It's just simply to try and hide assets in some other entity. And one thing that has to be noted about a trust is that a trust does not create a separate legal personality. A trust is simply a vehicle that is being used to hold assets for the benefit of another person. Beneficiaries can also be a class of people. So, for example, I can say, I'm creating this trust for the benefit of all the people that are in Bobono, right? That is something that is allowed. There are different types of trusts in Botswana. There can be trusts that are created for purposes of dealing with issues of inheritance, which is called a testamentary trust. And there can be trusts that are non-profit trusts, where it is an organization that is created in order to further some sort of cause. These are simply examples of trusts that can be created. There can be trusts that are created for educational purposes and so on and so forth. The Trust Property Control Act came into existence in 2018. However, between 2018 and now, there have been various amendments to this act, and then we finally ended up with this Trust Property Control Act number 4 of 2022. Now, before the 2018 Act came into existence, a trust was ordinarily created by way of a notarial deed of trust, which was simply registered at the deeds registry. However, when this Trust Property Control Act came into existence in 2018, trusts were required to also be registered with the Master of the High Court. And this registration is still required in terms of this new act being number 4 of 2022. And in this registration, one registers the trust. They also register the trustees. And on top of that, during the registration process, they also indicate who the beneficiaries of the trust are, the person who controls the trust, as well as the person who created the trust, being the founder or the settler. Now, the trust, through its officers, can apply for this registration, or they can use the services of a trust service provider. And this trust service provider has to be registered also with the Master of the High Court. However, there are people that can assist you to register a trust without needing to register as a trust service provider, and examples of these people are attorneys. If a person is acting as a trust service provider, but they do not register as such with the Master of the High Court, then they are liable and may be charged 500,000 pula or 10 years in prison. And the existence of this law, being the Trust Property Control Act, has put the power to deal with trusts in the hands of the Master of the High Court. And if you're following me on my Facebook page at Botswana Thinking Law, or on my Twitter at BW Thinking Law, you will know that from time to time I do talk about the powers of people that act under the administration of justice. Before, I had put up the duties of the master and the powers of the master when it comes to estates. Now, this new Trust Property Control Act since 2018 has put the power in the hands of the master to deal with trusts, meaning the master has the right to appoint trustees, the master has the right to remove trustees, the master has the right to ask for security for a person to act as a trustee. They have the right to ask for so much information in relation to the trust. And this is to ensure that the trusts in Botswana are not used in order to launder money or some sort of illegal activity. A trustee can only act as a trustee if they have been given letters of authority by the Master of the High Court. Once a trustee has been given this property that is being donated, and when a trust is established As I said, there's this initial donation, but there is nothing that stops the trust from actually generating more money from the donation or continuing to receive more donations as a trust. Once this has been done, although a trust is not a separate legal person, it exists through the trustees. The property of the trust does not mix with the property of the trustee. When this Trust Property Control Act number 4 of 2022 came into effect, it extended certain deadlines that had been put in the Trust Property Control Act of 2018. And this deadline is that all trusts created before 29th June 2018, right? If your trust was created before 29th June 2018, then it has to be registered with the Master of the High Court by 25th August 2022. If the trust is not registered with the Master of the High Court by that deadline, and this is in relation to trusts, like I said, that were created before 29th June 2018, then that trust property is going to be forfeit and the trust will be null and void. And when it is forfeit in this way, the trust property will then fall into the void trust fund, which belongs to the government. Meaning, if there's a trust at the moment that was created before 29th June 2018 and it holds a house, for example, or it holds 1 million bula, and the trustees or the officers do not register the trust by 25th August 2022, then that house or that money falls into the void trust fund and it does not belong to the trust anymore, meaning the beneficiaries would have lost out. And there is no process set out in the Act that shows any way to get that property back. And it is for that reason where the trustees fail to register the trust, then they are guilty of an offense. Now, there are many duties of a trustee, so make sure to keep following me so that you can watch part 3, like I said, where I dig deeper into the duties, and there are many duties of the trustees. That being said, thank you for joining me. I hope you got something of use from this video. Make sure to like, share, subscribe, ring the notification bell so that every time I put up a new video, you get notified. And make sure to follow me on my social media, like I said before. And I hope to see you in part 2, where now I go into detail about the content or what has to be inside a trust instrument. I will see you next time. Bye.